Hi, this is Jim Cunningham, and today we're going to be talking about trustees at risk, how to avoid being sued or even jailed. I've got Randy Catney's here, my good friend, and he's going to be going through, with our time here together today, he's going to be going through with me all of the ways that trustees can get in trouble. And frankly, many of the ways that trustees have no idea, right, what they're getting into. They can really get in trouble. Super important. Randy and I are both lawyers. We're both experienced lawyers. This is absolutely not legal advice. Do not watch this and say, Randy said or Jim said, and I'm going to go out and do a bunch of stuff. That's just a bad idea. If you're watching this on YouTube, hit subscribe to our YouTube channel and hit the little alert. And as we release these YouTube videos, it does pop up in your feed. So it's a great way to stay on top of all of the changes in the law. And we're going through, I would say, a season of change in the law. Randy is a good friend of mine. I've known him for well over 20 years. He's a partner at Catney's and Wells, 30 years litigation experience, located in Westlake Village, which is right at the edge of LA County on the way to Ventura County. And he's handled many contested trust matters, power of attorney matters, and probate matters. And he has reached many resolutions by settlement, mediation, and trial. And I have had the pleasure of, in my days when I litigated cases, Randy and I did litigate together. But that's a young man's game, Randy. And I don't know how you keep doing it, but you're great at what you do. I'm the managing partner, CunninghamLegal, 25 years experience. We have offices throughout California. I'm a certified specialist in estate planning, trust, and probate law, a real estate broker, securities and insurance licensed, and a pilot. And this is our team of lawyers. We have offices throughout the state of California, Northern California, and Southern California. I'm joining you today from Sacramento, just a short 20-block walk from our state's capital. Trustees at risk. They don't know what they don't know. Randy, isn't this an honor? Shouldn't you always say yes if you're appointed as trustee?
Well, my response to that would be, I would not always say yes. You need to understand what you're getting into before you say yes. Remember, if you do say yes, you take on an obligation, which is a fiduciary duty. Fiduciary duty is the highest standard of care, the highest obligation you have to someone. So a lawyer, for example, has a fiduciary duty with clients. If you're a trustee, you have fiduciary duties. And what that means is whatever you do or you don't do is going to be measured by that duty. So before you say yes or before you accept it, carefully weigh what's going to be required of you as a trustee with this fiduciary duty in place.
Yeah, you know, and I've seen trustees inadvertently step in it. And I would say that, you know, some people say, well, this kind of happens all automatically. You know, I'll just follow the terms of the trust. But the problem is there are a lot of things you have to do that aren't necessarily written in the trust. And there's really zero guidance on the trust, right? So these are just laws that are out there, things you have to do. I would say inaction is one of the areas that we see the most problems in. And it does result in income tax penalties. Frequently, property tax penalties, I would say, is the most common one when property is reassessed. And then, of course, death taxes. And this results in civil liability, right? So the trustee has to pay money, potentially criminal liability, you know, if you take all the money out and pay your kids' college tuition. So trustees are always personally liable. And again, even if you follow the terms of the trust to the letter of the law, there are plenty of other stuff, plenty of other laws you have to follow. And as we said, as we were getting ready for this, Randy, no good deed goes unpunished. Isn't that correct?
Correct. Yeah. And, you know, it goes with that phrase, you don't know what you don't know. And I, you know, the unfortunate thing is in 30 plus years of litigation, I've used this phrase, unfortunately, frequently. And where these typically happen, and, you know, you need to know the landscape too. For example, if you're going to be a trustee, whether you're agreeing to act in advance as a trustee, somebody tells you, hey, I'm going to appoint you as my trustee, or you find out later you've been appointed as the trustee. You know, you need to be aware of the emotional landscape, because what you have to keep in mind is who are the beneficiaries, because as the trustee, your obligation flows to the beneficiaries. So if you have a group of beneficiaries who may be family members of you, if you're the trustee, they could be strangers, they could be charities. You need to know, are these high risk beneficiaries? What does that mean? Somebody who likely is going to sue you or going to claim that you've done something wrong. So if you have someone on the other side, let's say it's a family member, and they've been in 5 lawsuits in their lifetime, that's a pretty good signal that, you know what, they're probably going to be in a lawsuit with you.
You think?
So that's the first thing, is know your landscape, know who the beneficiaries are. Secondly, good communication, very important. So if you do decide to be a trustee, find out who are the beneficiaries. Very good to talk with them. Find out what their expectations are from you as a trustee, but also hire somebody like Jim Cunningham or his firm, because they're going to tell you right up front, okay, these are the minimum things you need to be doing. One of those things is you have to send out a notice under Probate Code 16061.7. What is that? When somebody dies and now you're the trustee, you have to send a notice to the beneficiaries telling them, hey, you can get a copy of the trust if you want to see it, or here is a copy of the trust and the will. So those are certain things you need to be aware of. Jim, I'm going to let Jim chime in some more, but again, to answer Jim's question, before you say yes, before you continue on as a trustee, it's very, I would highly speak to an attorney and know who your beneficiaries are.
Well, what we're going to do today, I think that, the headline from this is engage a competent attorney early on, a savvy lawyer.
Yes.
We're going to take an insider's view, because one of the great things about these webinars that we do for our clients and friends is I really try and pull back the curtain and give you an insider's view and really how lawyers view this. Because if you're a trustee, it doesn't really matter what you think or how you view the world. It doesn't really matter how the beneficiaries think or view the world. It matters how the lawyers interact, because ultimately it comes down to the lawyers. So we're going to give you that insight. And this is about your awareness. So as I say, safety first, let's go. And we're going to talk about traps. As you pointed out, Randy, lack of communication. I think this is like the biggest one out there, right? I get these calls where they say, Mom died 2 years ago. I haven't talked to my brother for a year and a half. He's still living in Mom's house, and that house is supposed to be sold, and I'm supposed to get half the money. That we get those calls, if not once or twice a day. We're getting them very frequently, okay? But too often, people don't even know they're being appointed, and children are appointed either sort of knee-jerk in the order of birth, or the client says, I got 5 kids, I'm going to appoint all 5 of them as trustee. I'm not sure that's a great plan. Even a small estate is a large estate. Most real estate in California, many places are over $1 million. So even if Mom just only has 100,000 in the bank and a home, many times that's $1 million estate. So even these small estates are big enough to fight over. And I will say, 10 years ago, 20 years ago, that really wasn't the case, because real estate's really gone up tremendously in value. And this is an interesting one, the reasonable man. And of course, law is very, I guess, paternalistic and male-centered traditionally. And this is what is known as the reasonable man in law. Have they changed it to the reasonable person? I don't know. I think we still hear about, maybe it's reasonableness now. But you have to exercise your fiduciary duty with ordinary care and diligence, and you've got to take steps to preserve the estate. So you have an affirmative obligation, if you're a trustee, to do something, right? And you want to talk about a reasonable man. What are we talking about here, Randy? What is this reasonableness concept? Because it does not exist in, if you're from Europe, from continental Europe, this concept does not exist in Europe. This is purely an Anglo-American concept. So maybe touch a little bit on what reasonableness is in the law.
Let me do that. The thing about American law, this is something that applies really almost uniformly across the spectrum of law, whether it's contracts, it's torts, it's trust, and really what the reasonable person standard is, or what's reasonable. What I view that honestly as, it's kind of like if you've built a home and your miter joints don't really fit together perfectly. So what do? Well, you're going to put a strip of wood over it to hide it, because it doesn't fit perfectly. So it looks better. And so first of all, it's designed to take care of situations where it's not really clear on what the outcome should be. So what are we going to resort to determine the outcome? We don't have a clean fit at the joints. Okay, what's reasonable? Then when you talk about reasonableness, what happens? Who decides what's reasonable? It could be a jury, it could be a judge. In trust estate litigation, the statutes are pretty clear that the judge will decide this. Now, with financial elder abuse, physical elder abuse, the legislature said in California, hey, we can have a jury do that. but generally it's going to be a judge. So it's whatever she or he considers to be reasonable. And that's pretty scary, isn't it? Because if you think about it, I'm going to go to court, my lawyer's going to go to court. What's reasonable? Normally, what will be determined as reasonable, it's facts and circumstances dependent. And many times you have to bring experts in. For example, part of what we're going to talk about today is the prudent investor statute. What does that mean? If you're a trustee and you get appointed or you take over a trust, you can't just sit there and just let the thing run itself. You have an obligation, as Jim just said. What assets do we have? Do I need to reposition these assets? Do I need to improve this real estate? Do I need to sell the real estate now? Do I have a renter? Do I not have a renter? Do I let the son or the daughter or this relative continue to live in the home after mom or dad died or what have you? So reasonableness is going to be determined by facts and circumstances. And then you can get an expert. The expert might come in and say, listen, I worked at Charles Schwab Company for 10 years. I'm a registered investment advisor, and I've looked over this portfolio, and I think this trustee acted reasonably given the conditions of the market. Could they have made more money? Yes, but they acted reasonably. So to summarize, to answer you, Jim, it's facts and circumstances driven. You're going to need experts from time to time. You're going to need to look at also what is the estate made up of. And then lastly, remember, a court, a judge, or male or female at some point is going to determine what's reasonable.
Yeah, and I think the point here is you think by setting up a trust, you're keeping it out of probate court, which a trust is designed to be out of probate court, but the trustee has to do their job, because one of the things that a trustee is and why this reasonableness is so important, a trustee is an extension of the justice system. A living trust is a probate replacement. The probate process is part of the judiciary, right? It's one of the three branches of government. And when you opt out of this judicial process, that comes with tremendous responsibility, right? And as we're going to see, if you mess up, you can go to prison. So prudent investor rule, as you mentioned, the trustee must consider certain economic conditions, tax consequences, total return on assets, diversification. There's something called an investment policy statement. If you do not have an investment policy statement, and we have some materials on this in our YouTube page, the trustee is personally liable for any stock that goes up or goes down. So you really need to take this very seriously. If you have a litigious beneficiary, you could find yourself in court. And the problem is you won't know until it's over, right? That's called 20/20 hindsight. Now, reasonableness, when it comes to fees, one of the common questions is, how much can I take as a fee? The vast majority of trusts that I see, the vast majority say the trustee is entitled to a reasonable fee. What is that? That is county specific. I have heard that 1% is reasonable in Napa County. That is not reasonable in Ventura County. So it's county by county. Which county do you pick? It's typically the county of residence of the trustee, typically, or where most of the trust administration occurs. And again, you got to comply with this prudent investor rule. Now, and a trust can expand or lessen these rules, and the trustee is not liable if they're lessened, even though the law requires a higher duty, the trustee is not liable. And this applies to all trusts after 1996. And again, a trustee has a general standard of care like the prudent investor rule. And I would say, know the facts and circumstances, know the trust terms. This is another one. Trusts are often written in legalese. If you're a lay person, a lay trustee, you may not understand what these terms mean. These are terms of art. A word like issue has a very specific meaning. It means the surviving descendants of a deceased person. That's a technical meaning. It doesn't mean legal issue. It means it's identifying a person. So seek out expert advice. I would say seek it out early on. And when in doubt, go to probate court. And this is our commercial for Trust Protector. So you may be watching this going, Jim, this is really starting to tick me off. I did my living trust to keep it out of probate court. Why do you keep talking about probate court? There is a role, or there's a thing in the law called a trust protector. A trust protector is an individual who has power over the trust, but is not the trustee. So something to understand, a trustee cannot deviate from the terms of the trust. The trust is written, the trustee has to follow the terms of that trust. The only way they can deviate from the terms of that trust in most cases is by going to the court and having the court modify the terms of the trust or otherwise instruct the trustee on a certain action. So here's an example. If the trust says, The trustee is going to drive from San Francisco to Los Angeles on Highway 99, which if you've ever driven between San Francisco and Los Angeles, nobody takes Highway 99. You have to go through Fresno, all these cities. It's like stop and go traffic, bunch of ag trucks on there shipping tomatoes and asparagus or whatever they move around. Highway 5, easy, straight shot, boring, but a lot quicker, a lot more efficient. If your living trust, when you pass away, says take Highway 99, the trustee has to take Highway 99. If the trustee wants to take Highway 5, they have to go to probate court unless you have a trust protector who can change the term of that trust. Now, let's talk about, Randy, you and I know one attorney who embezzled. A fiduciary duty is the highest duty under the law. You have to put the interest of the beneficiaries. By the way, what is a beneficiary? A beneficiary is the person who gets the good stuff, bene meaning good in Latin. A beneficiary is the one who gets what is in the trust. So what if you borrow money from the trust to pay personal gambling debts, which did happen in one case that I was involved in? What happens to this person, Randy? What are the parade of horribles?
Well, okay. First parade of horribles, which is the lowest, is they take the money, they return the money, no injury, no damage to the trust. Is it a breach of fiduciary duty? Yes. However, one of the elements is, has the trust suffered any damage? If I were a judge with all my experience and I saw this, I'd remove this person as a trustee, but I wouldn't hold them monetarily responsible because the trust didn't suffer any damage. Maybe interest was lost or some type of investment opportunity. And again, it's fact and circumstances dependent. If the trust had an opportunity to invest in something and it was designed that way, maybe to put money in some type of a bond or something for somebody's education. Jim hasn't talked about, but some of these trusts have, they're not just a trust that's going to stop once you distribute. There could be a special needs trust in there, all kinds of things that maybe the trust goes on. Maybe there's a property they want to keep in the family and they have a special part of the trust that says, hey, we're going to maintain this property because it's at the beach and we want our relatives and children and grandchildren to enjoy that. But to answer again the question, you spend the money, you return it. Bad, probably get removed as a trustee. Second, you spend the money and you don't return it. That's really bad because under the law, one, you can be discharged as the trustee, which court I feel would do that in a heartbeat. And secondly, you under the civil side, you are responsible for 2 times what you've taken. So we're going to talk about this probate code here in a second, which is 859. But bottom line, in the probate code, it tells the trustee, look, if you lose money, let's say gambling, which is egregious, let's say it's 100,000. The court can say, not only am I going to remove you, but you have to pay back 200,000. And then I'm going to make you pay interest, which the law also allows on that money. And if it's bad enough, maybe I'm going to hit you with punitive damages because maybe that money was supposed to go for the care, let's say, of somebody who maybe is like a Down syndrome child or something that was really important to the people who set up the trust. And because you took that money, that couldn't be done. So again, I could go on and on, but the point I want to stress is, if you're a lawyer in California and you have money in your law firm trust account, if you take $1 of that, you can be disbarred. You can be disbarred for taking $1. It's a lot like that in the trust situation. If you misuse trust money and you get caught, it's really bad. And what happens sometimes is as a trustee, you're not trying to intentionally take money. It might be where somebody shows up, you're remodeling the house because you're getting it ready for sale. And the contractor says, I don't want you to pay me with checks. I want cash. So you as a trustee say, okay, I'll give you cash. Well, I need it right now. And as a trustee, you run over your ATM, you run over to your bank, you take personal money out of your bank, you give them $2,000 in cash. And then later you go back to the trust and you write yourself a check for $2,000 reimbursement for cash you gave the contractor, but the contractor never gave you an invoice and now you don't know where he is when problems happen. So again, like Jim said, very important, have somebody like Jim available. And even if you meet him for a couple hours to start with, once you start administering the trust and you're taking care of selling the home, getting it ready for sale, give Jim a call for 5 minutes, 10 minutes. Hey, Jim, do you think it'd be a good idea for me to give cash to this person? And Jim or whomever works for him might say to you, no, not really a good idea without some documentation.
Yeah, Randy, you kind of highlight, I think one of the most frequent in many respects, low level issues that come up. It's like, what was this $20 for? If you take money out and buy a pack of gum and chew it, and you're the trustee and you use trust funds, technically that's embezzlement, right? So you really pay attention to that. So Mario asks, does this also pertain to a special needs trust? Are there other things that need to be considered in a special needs trust that would not be addressed here? Yeah, I would, as we were preparing for this, a lot of American law is based in Judeo-Christian culture, for lack of a better term. And there's this concept of widows and orphans, and there's this concept of protecting people who can't protect themselves. I think a court really pays attention to that because judges are in public service. Judges frequently, when they become a judge, they may take a really big pay cut from being a private practitioner. You may not realize this, but I think a lot of judges, they're public servants. They have a heart for service and they want to do right. And if you steal from a disabled person, I think that's viewed worse than stealing from Randy or me. Okay.
Yeah. And the other thing, just real quick to add on what Jim said, keep in mind in the court system, there's two types of law. There's equitable law and there's legal. What does that mean? Well, when you're in probate court, which really kind of misnomer because it's not just probate, it's a state law, trust law, what have you, but let's say probate. The judge sits in equity. What does that mean? The judge can do what they think is fair. And I'm saying to all of you out there, if you have a trust and you think that trust can't be changed by a judge, I am letting you know, I have broken many trusts, many, on the idea of fairness, where we've gone to the judge and we said, you know what, Your Honor, this trust is not fair. And here's why it's not fair. And if the judge agrees, they'll reform the trust. What does that mean? They'll modify the trust. They might even throw out the first trust and make you do a second trust. But Jim's point is they do look to do what they think is fair. And once they form an opinion as what they think is a fair outcome, then they're going to do what they think is appropriate to rectify the wrongs.
And many times you would think, well, I can just appeal that. Not every court order is an appealable order. What that means is not every order that a judge makes can be reviewed by the appellate court. Okay, so that's very important. And many times what we're talking about is not subject to court review at the appellate level. So,
and let me add two more things. Even if it goes up on appeal, a judge's discretion is one of the hardest things to win on appeal. If you have an error of law, you might have a good chance on appeal. But if you have something where the judge is exercising discretion, the law basically says we are going to presume that the judge's decision based on their view of the evidence, based on facts and circumstances and their exercise of discretion was proper. And the only way you can overturn that is if you prove they abused their discretion, which is very hard to do, very hard. And the other last thing I'll tell you is this. Jim mentioned the judges take this seriously. I have been in court, many courts throughout the state of California, and a beneficiary will come in and they'll say to the judge, my sister took $400 out of the trust and they used it for lunches, or they bought burgers or something for a family dinner. And and then they'll say, we want an accounting. And the client will say to me, I only took $400 and everybody knew we were at a family gathering. You know what the judge will do? I want an accounting. You got to make it code compliant. What does that mean? You got to follow the probate code and do an accounting for everything that you've done. So Jim's point is well taken. Just be careful whenever you're spending trust money.
So we have some questions here. Mon asks, you mentioned that a trustee can reside in the same county or the trust established in the county which won for reimbursement. What if the trustee is in a different state, not California? I think I understand your question. Here's another problem. People say, I want to name my son as trustee and he lives in London. He's a banker. He married an English woman. He's going to stay in the UK forever. Once your son becomes sole trustee, that is a foreign trust. You don't want a foreign trust. Okay. It just precipitates a whole host of problems with the IRS is the bottom line. What if, okay, say, all right, so then my son lives in the UK. I'm going to name my daughter. She lives in New York City as successor trustee. If somebody has a problem with that trust and you're a California resident, let's say, the proper venue, which means place in French, because we got a lot of terms in law from French. The proper venue or the proper place to file the action is, if she's in Manhattan, New York County. So you're going to have a New York County judge ruling on a California trust. Well, I mean, you can see where this is going. It's nuts. So really be mindful. And so when you name an out-of-state trustee, if you think there's going to be a problem, an out-of-state individual trustee, really know the issues and really speak with your attorney, you know, whether it's our firm or another firm, but speak with an attorney who really knows what they're doing. That's a savvy attorney, right? So Susan asked, my husband is trustee. The trust income goes to my sister-in-law, but the principal goes to his estranged niece and nephew, whom we don't trust. What kind of risk are we in? Well, Susan, your husband's the trustee of a trust where the income, now, by the way, so you can think of a cow like a milking cow. A cow gives milk, and a cow is, you know, made up of beef and bones, right? The income is the milk. The principal is cutting off, you know, a side of that beef. And I mean, it's kind of gruesome, but that's kind of the idea here. So what happens is the sister-in-law wants there to be maximum income, right? Which means the sister-in-law would want the trustee to take risk to generate more income. And the principal, which is the cow, the beneficiaries don't want as much milk coming out of the cow because they want that cow to get fat, right? Because when the mom dies, they get the cow. I think if there are people that you don't trust and they're estranged, what do you think, Randy? That makes me a little nervous. I think I would really engage a lawyer throughout the process.
I would. And it's like, remember what I said, survey who the beneficiaries are, get an idea of their emotional status. This is maybe what I would call a problem waiting to happen. And again, good communication. But before you communicate, I think it would be really helpful, consult somebody like Jim, maybe bring in a financial expert who can take a look at the situation and advise whether or not the assets are being managed. And Jim is right. You know, when you have an income beneficiary versus the beneficiary gets a residual, there are always going to be tension between those two, because like Jim said, income beneficiary wants maximum money today. And the residuary or the residual beneficiary is saying, I don't want you to take any risk where I'm going to lose any part of the basic principal amount. And as a trustee, that's can be hard to navigate sometimes. And that's why, and by the way, you can hire professional investment advisors by the hour.
Right.
So sometimes people will say, well, I don't want to hire an expert. They're really expensive. They're going to cost me $5,000, $10,000. Sometimes you can hire an expert and they're out there and you just pay them $250, maybe $400 an hour, maybe $500 even. But, you know, for 2 hours, $1,000, they can give you a lot of good advice. And then you can tell them, I want you to issue a letter to me. I want you to send me an email confirming our conversation and confirming the recommendations you gave me. Because as a trustee, if you're relying on counsel of a third party, i.e. a lawyer or a financial advisor, that is under the law very defensible conduct, because you did try and you were reasonable. You went out and you talked to experts.
Durable powers of attorney. So I would say that a durable power of attorney, even though it says attorney, has nothing to do with a lawyer. Okay. So this is a very confusing name for a document. They carry a durable power of attorney. Sometimes the person who acts on the behalf of the durable power of attorney can either be called an agent or an attorney in fact. Again, very confusing. The attorney in fact does not have to be a lawyer and is not, we're not talking about the lawyer. We're talking about the person who's acting. So in the same sense that a soldier serves in the United States Army, that would be an executor. And then a sailor serves in the Navy, that would be a trustee. This would be like the airman, right, who serves in the US Air Force. It's the same role when we say agent, attorney in fact, executor, trustee. But we use these terms of art so that when a lawyer says trustee, they use one word. We know that we're talking about the context of a trust versus executor. So these can be short documents. They can be one page. California's statutory form. You can go to the probate code and you can pull that power of attorney. It's in the law books. It's a form. You can just run it off on a copier or download it. These are frequently used for good. But Randy, as we were talking about, these are really dangerous instruments, and they are frequently dishonored in the real world, ITRW, in the real world. Oftentimes institutions will dishonor these, frankly, because there's so much abuse when it comes to durable powers of attorney. And I think many elder abuse cases involve durable powers of attorney, if not all of them. I mean, what are your thoughts on that?
Well, the thing is, let's just talk about the California form. I had a case several years ago in Orange County, and bottom line was, before, it was an older woman. She had a pretty sizable estate, and she was befriended by a neighbor, and she was starting to, she didn't have a lot of family around her, and this neighbor ingratiated himself with her, and she ended up giving him a power of attorney. And once he got that power of attorney, he's going to her bank, he's taking cash, he's going to the bank, taking cash. I mean, like $10,000 every 2 weeks in a brown paper bag. And, the bank should never have let him do that after the first instance. Even they should have stopped them immediately. I think banks are better about that today. But here was the thing, at trial, we did have the power of attorney. It was the form Jim talked about, state of California. And I asked him, did you sign this? Yes, that's my signature. Well, did you read it before you signed it? No. Well, let's go through what the provisions are. And one of the provisions in the form tells you it's a fiduciary responsibility. Other provisions tell you if you violate this fiduciary responsibility, you can be subject to criminal action. They're telling people in the form, look, this is a serious form and you're expected to exercise it with good intent and to do it properly. I personally tell my clients, I do not like powers of attorney. I think they're dangerous. I think they should be, there should be a requirement for court supervision of these, but we don't have that currently. And probably because the outcry would be, well, the courts are busy enough, they're not going to supervise these power of attorneys. But remember, when you give this out, and let's say you are the person getting it, you need to know, again, who else is involved. And sometimes this is a scary part. When the people die and you become the trustee, you know who the beneficiaries are. But when the person's alive and you get the power of attorney, you may not know who the beneficiaries are, because generally while the person's alive, you don't really have a right to see their trust or their will. I mean, that's California law. The person's alive, so you may not know who the beneficiaries are. So here you are doing the power of attorney thing, and you're helping mom, or you're helping dad, or maybe you're just a neighbor or a friend, like a longtime friend. You're paying your bills, you're writing the checks. I mean, my advice to anybody out there, whether you're a family member or not, really think hard before you take a power of attorney and agree to that. And if you do agree to it, I would communicate with known beneficiaries. They could be family members, your siblings, what have you. Let them know you have it. Let them know that you will communicate with them about what you're doing, because what happens a lot of times, you have a sibling, they're the caretaker, they're the caregiver. Now they have the power of attorney. Mom dies, and the other siblings find out that they had this power of attorney, and they get really upset, because the first thing that happens is their spouse starts whispering in their ear. Let's say it's your sister or your brother. Oh, your brother ripped you off, or your brother took this money. And next thing you know, the letters start coming from the lawyers, and then it gets out of control. So Jim makes a good point on this.
Randy, that is so true. If you're the trustee, let's say there's you and two siblings, and your siblings are married. That's not two people you got to worry about. It's four.
Correct.
Right? Because the spouse is in the ear, and we see that frequently. This is a, this is a little sensitive for me personally. I will tell you why, because I have talked in my 25 plus years experience with lots and lots of advisors and a variety of advisors. And I would say there are informed, and frankly, I would throw lawyers in here as well, because I talk to some lawyers and who say, yeah, I do trust administration. They don't know anything. And they say, just file an affidavit of death, sell the property, write checks to your brothers and sisters. You don't have to deal with the rest of that stuff. Uninformed CPAs, uninformed financial advisors are trying to do well. I believe that these individuals are trying to add value by keeping the fees low. All right. I get that. But what I've heard too often is a CPA saying, you don't need a lawyer. The trust says to sell the property and give the money to your three siblings, right? But there's a lot more that you have to do. And the CPA doesn't see that, because the CPA, it's kind of like the three blind men and the elephant, right? The lawyer sees the whole elephant. A CPA goes, an elephant's a wall, right? And then a financial advisor says it's a rope. So people say, what could possibly go wrong? There's a lot that can go wrong, even if you follow the terms of the trust. I would say a newly minted trustee, first of all, the 13th Amendment to the United States Constitution outlawed slavery. Thank goodness, right? It also, what it actually though did is it prohibited involuntary servitude. You do not have to serve as trustee. If somebody names you to serve as trustee, you don't have to do that. All right. But once you do serve as trustee, you know, you kind of, now you got the wolf by the ears, right? There's a lot of stuff you have to do. And a newly minted trustee should immediately, and when I say immediately, that means like now. So seek out savvy legal counsel. And really the determination is you need to seek out a lawyer to find out if you need to hire a lawyer. So sometimes you need a lawyer, sometimes you don't. Sometimes one meeting with the lawyer is enough. You know, I'm an only child. I think if you're an only child and mom and dad pass away and the only thing they have is a house and you're in escrow and you go out and seek out a lawyer, there's some things that you have to do, but I think the lawyer's involvement is really minimal. If you have if you have not been doing anything as trustee for 3 years and you've been living in your parents' house and spending the money out of the trust to live on, and you got 2 siblings that you're supposed to split everything with, you're in hot water. You need a lawyer, right? Because you're in a hole and you're gonna have to climb yourself out of that. So any thoughts on that?
Yeah, let me jump on this too. This is important. Again, keep in mind, there's a difference between Jim's normal day and my normal day. Jim's normal day, he's writing things, he's doing trust counseling, he's doing tax counseling. My normal day is I'm at the end of the road when the train is blown through the exit and hit a building. We're not riding on the train's crashed, and now we have to figure out what to do. So what I'm going to say here is not meant to make people nervous, but it's to help you. And here's what it is. In the law, when you talk with your lawyer, it's deemed privileged communication. Jim alluded to that earlier when he was before a judge, and he said, I can't tell you. With an accountant or a financial advisor, there's no privilege. What does that mean? Let's say you contact your CPA and they're talking to you, and the CPA tells you, you know what, we're going to have a big time long-term capital gains problem here, or we're going to have some tax issue and we don't have the money to pay it. So you're going to have to liquidate some things. And he tells you, maybe, let's say it's legitimate advice, send you an email telling you that. Then you send an email back and you say, well, I want to think about that right now. And the CPA writes you back saying, you know what, we have 60 days to deal with this. Otherwise, we're going to incur penalties and interest. And you write back, I want to think about that. Later on, if a beneficiary gets a hold of that in discovery, if there's a lawsuit, it's really bad. So when you're dealing with the CPAs, when you're dealing with the investment advisor, if you go that far, try to verbally understand what they want you to do and what they're telling you, and try to limit these emails back and forth if you know you're in risky territory. And your heart will tell you, right? You'll know, okay, I got to be careful here. The moment that you have a little red flag come up, like I have to be careful, that's when you should pick up the phone and call someone like Jim. And call Jim. I've worked with him a long time. He's very good at what he does, and he's very competent. And you can save yourself a lot of trouble by doing that, because again, you're for a lot of people here are going to be the trustee, never done it before. I'm somebody that flies an airplane, or I'm somebody that runs this company, or I'm doing this. I have no idea how to be a trustee, right? It's kind of like being a parent. You don't go to school to learn to be a parent. You just are. And so again, it makes sense to contact the savvy lawyer like Jim to help you when you get in these situations.
Well, let's talk about beneficiaries' rights. Okay, so trustees have duties and beneficiaries have rights. Trustees are frequently punished for breaching their rights. Beneficiaries are rarely punished, if ever, for exercising their rights. So something to understand is the trustee is a big fat target. And you may think, oh, well, there's a no contest clause. If the beneficiary files anything in court, they don't get anything. Well, we're going to see in the next slide that's not the real world. So let's look at an example here. Mom, M, dies, she has 2 kids, trustee and brother as beneficiaries. She names T as trustee. So mom's got 2 kids, and the trustee that she's named gets emotional, which is really not uncommon because losing a parent is an emotional time. It brings up a lot of stuff in your life. And it's, for those of you who've lost a parent, you know what I'm talking about. And then the trustee starts acting unreasonably and then ignores the brother. And then, of course, mom gave the trustee child a little bit more because the trustee child was there taking care of mom for 10 years. Meanwhile, the brother was on the East Coast and not really in the picture. And so what does the brother do? Well, the brother claims that the trustee failed to account and mismanaged the accounts and spent money in a way that the brother says is wrong. And this parade of horribles, breach of duty, petition for removal, petition for surcharge, damages under probate code sections 259 and 859, and B, the brother seeks punitive damages against the trustee personally. All of that, B is not challenging the trust. Any thoughts on that? You see this often, Randy?
Yeah, and I would just tell people who are out there, when I represent a trustee or a party where somebody's claiming there's some irregularity regarding the trust, mom didn't know what she was doing. That would be called lack of capacity. My brother told mom that if he didn't give him 60% of the estate, he wouldn't take care of her anymore, would withhold food from her, wouldn't take her out on walks anymore. That could be deemed what we call, unreasonable control, meaning he's acting in a manner where he's usurping her ability to act volitionally, or meaning her consent, or what we call undue influence. And so you just have to be careful here. So what I will typically do is, here's the thing, just to remember, if you're somebody out there and you're challenging a trust, if you don't have any inheritance, for you, it's a no-brainer. Challenge the trust because you have nothing to lose. But sometimes what smart lawyers will do is they'll say, so-and-so we think is going to challenge the trust, so we're going to give them $100,000 as a gift. And so that would discourage them, because if they challenge the trust under the no contest clause, if they lose that $100,000. So sometimes we get cases where somebody will make a claim, well, the trustee did this or mom did this, and somehow they inartfully say things in the pleadings, which could be deemed a direct or what we call an indirect contest. So then we'll file a petition against the party who brought it, saying, hey, you contested the trust, you lose your inheritance. And sometimes it's like $250,000 or more. And when we file those petitions, what happens is, we're going to talk about this a little later, the court will send you to mediation eventually. That's just how it happens in California. Mediation is non-binding, but the court wants you to try to settle. Well, when you get into mediation, most of the time it's a retired judge. It might even be an active judge, but not your trial judge. And you know what they'll do with that petition for no contest? They'll use it as a sledgehammer on the other side, saying, hey, you know what? If you don't settle, you could lose your inheritance. So again, it's just another area to be careful with when you're out there initially reacting to things that happen in a trust context.
A lot of people name an individual, and I would say that, this is the kind of the fork in the road. And when we were talking here, I've named an individual as successor trustee in my trust, and you've named somebody not your kids in your trust.
Correct.
So
yes,
but we've named individuals, and sometimes it's good to name an individual who's competent. Sometimes, it might be a child. It could be co-trustees. Now there's kind of a split. Some attorneys say never name two trustees, and other attorneys will say, oh, it's okay. I think it depends, right? It's case specific.
Facts and circumstances, and who the beneficiaries are.
For sure. But I would say trust companies and trust banks generally know enough to stay out of trouble on the basics, right? On the day-to-day administration. They can, to a certain extent, trust administration is like digging a ditch a quarter mile long with a 2-degree slope. It's not rocket science. You just need to know what to do, and then you need to execute and do it. Okay. But when a non-professional trustee, what I mean by that is an individual who doesn't know, that can be problematic. So if you don't have anyone, you can consider name a corporate trustee. There are trust companies and trust banks. A trust company typically will not manage the underlying assets. A trust bank will. Trust banks charge higher fees. Trust companies charge lower fees. Trust banks will fire your advisor and suck up all the assets and put them into proprietary funds. And trust banks typically won't do that. We've covered that in several other YouTube videos, and I would encourage you to check those out. But I think if you're going to have an unequal distribution, if you're going to give one kid 2/3 and the other kid 1/3, and you name the kid who's getting 2/3 as successor trustee, that could be really problematic. And I think that that's something where you might not be doing that one kid a big favor. So I kind of call the no contest clause. And again, to this point of like, oh, well, wait a minute. If this beneficiary files a lawsuit, they don't get anything. Don't they forfeit their rights? No, not all the time. Sometimes, right? I call the no contest clause has become the Santa Claus. In California, this is effectively unenforceable for most cases that are filed in California. This leaves the door way wide open for court filings. I would say the most common one is an allegation of some type of breach of trustee duty, accounting, surcharge, removal. That is not a challenge. Okay. So in the trust, in most well-written trust, in the boilerplate, and by the way, boilerplate has a negative connotation. Boilerplate is your friend because those are well thought out elements that need to be in trusts. Okay. But I think if they're well prepared, a trust will give a trust will permit the trustee to hire a lawyer to defend the trust. It's a very important term that you need to have in your trust. And I don't see that in all trusts, Randy. I review a lot of trusts. But if the beneficiary does bad stuff, if a trustee does bad stuff, a beneficiary asks the court to cut the financial payments to the attorney for the trust. That shuts off the money flowing to the attorney who is trying to defend the trust. And that really hobbles the trustee. And now the trustee has to come up with his or her own personal funds, right? Which can be really problematic. And I would say if there's a tip, don't think that any court filing triggers a forfeiture, triggers the no contest clause. How many times do you see the gravy train getting cut off, Randy?
Well, let's talk about this for real quick. When you're in litigation, right, it's kind of like you're fighting a war, it's civilized war. So what do you want to do? Well, let's cut off the gasoline that they use for their tanks, right? Well, what is that? Well, let's get the judge to say that the trustee, let's say you're a beneficiary suing a trustee. Let's get the judge to say that the trustee can't use any trust assets to pay for their legal fees. What will the trustee typically do if the court makes that order? They're going to resign.
Yeah.
Most of the time, they're going to say, I'm not going to spend that money to defend myself here. Now, they might, if they're still individually liable, they'll usually resign. So a tactic that lawyers will use frequently is they bring a claim trying to remove the trustee, and then they say to the judge, this trustee's so bad, don't even let them use money from the trust to defend themselves. But like Jim said, most trusts do have this clause, but sometimes it's not written very well. You want to make sure if you're going to help your trustee to have a clause in there that says that the trustee can use trust assets to defend the trust. Now, what does that mean? If the trustee individually does bad stuff, and it's so outrageous, like Jim said, gambling money, gambling trust money, then the court might say, no, I'm not going to let you use trust money to defend this trustee because they weren't doing something within the scope of their duties. They weren't being reasonable. In fact, they acted wrongfully. But let's just assume the trustee is being reasonable and they're trying to do the right thing and they haven't acted so far out of bounds that a court would say at first glance, hey, they're wrong, we need to remove them. The court's going to allow the trustee to take money from the trust to defend the trust. So very important to know that. And just be aware too that the trustee has the right to not just employ lawyers, but experts, CPAs, investment advisors, and can use money from the trust to pay for their services. Why do you think that's a good policy? Because it helps the trustee do what? Live up to their fiduciary duty, which benefits who? The beneficiaries. And that's why that's a good rule.
COVID, obviously, we can't talk about anything involving courts without COVID. We're talking, there's a court that we appear in regularly that is extending its closure. So people can't come into the courtroom. So this COVID thing is, it kind of rears its head and then puts it down and rears its head and puts it down. But the bottom line is, at least right now, courts really don't want you to show up. Okay. It's slowed everything down. And there are rarely in-person things happening in court. This may or may not be a permanent condition. I talked to different retired judges. I talked to different practitioners. I think there are elements that will be permanent, but it remains to be seen. Some, what we call ministerial hearings, are okay by phone or Zoom, a status conference, a matter is approved and you're just getting an order. But I would say, and Randy, when it comes to removing a trustee and cutting the cash off, I think it's important. It's important for the trustee to show up in appropriate attire, appropriate professional attire, with clean fingernails and
I agree.
you know what I'm saying?
100% agree with that. It used to be, just so everybody knows, and there's lawyers out there, you guys all know this, ladies and gentlemen. The courts typically wanted you there in person. They didn't really even want you to appear by telephone for the longest time. They wanted you in person. They wanted to see you. It didn't matter if you had to drive down to the courthouse. It didn't matter if you had to wait through a calendar. It just didn't matter. That's what they wanted. But it was old school. Given what's happened with COVID, I think the courts are realizing, you know what? This remote thing's not so bad. You can do it by phone. You can date. A lot of courts have special Zoom where you can attend by video, and then all the courts do it a little differently. Unfortunately, there's not uniformity there, but they allow that. But in certain circumstances, particularly where somebody's saying a lot of bad things about your client, and if you are a trustee, show up and meet the judge, talk to the judge, because that's the person who's going to decide whether you get to remain as a trustee or not. And believe me, if the other side's hot and heavy about it, they're going to show up in person.
Oh yeah.
Because they're going to just read the riot act to the judge telling them how bad you are if you're the trustee. But a lot of times what I've seen is the trustee shows up, again, like Jim said, dress appropriately, good explanations, at least on a preliminary basis for what you're doing. And the courts are going to be reluctant to remove you as a trustee if you're in fact doing what, at least at first glance, appears to be reasonable.
Now there's a way, what we're seeing is our filings are delayed 4 or 5, 10 months in certain counties, other months not. You can and I believe it's some counties have approved private judges to handle your matter, to expedite it. So that's another reason to hire a savvy lawyer. And again, this is a tip and sort of an inside tip. If you have a general practitioner who just doesn't know, that's bad, right? Because there may be a way to expedite things. Blowing off mediation when there's a contested matter. Look, if we were physicians, I would be the dermatologist and Randy would be the specialist who treats sepsis. Okay, so we see different patients, different clients. Many people are open. And what is mediation? Somebody files a lawsuit or not, but let's say typically they file a lawsuit, and instead of going to a trial, they say, you know what, let's just get the parties together and see if they can settle this matter and come to terms. If you are ordered to mediation by a court and you don't show up, there is a case out there that says if you blow off mediation, you're bound by the settlement agreement. So I think it's a bit of a heavy hammer, but who knows? So what are some other things to avoid, some other traps? Rehashing childhood. We say everything sees the light of day, and people will fight about things that either happened or they think happened during their childhood. Mom never would have done this to me. You unduly influence mom. Again, the caretaker often ends up with more. And unless the trustee has kind of stepped in it by taking some cash from the estate or doing something else improper, this is viewed as a weak argument. And I will say it's kind of the flip. I know of one case where the caretaker defendant who cared for the mother in a will contest, there was she's since retired, a judge in Ventura County who had taken care of her own mother and ruled in favor of the caretaker child. So courts do remove untrustworthy people because the court wants to protect the trust assets. And trust is something that's hard to build in a human relationship, and it is easily liquidated. It can be lost instantly. The same holds true. I would say, Randy, that courts give deference, meaning respect. They want to honor the terms of the trust. So they will give deference to someone who's passed away or become incapacitated of their choice as trustee. But a trustee can do one single thing wrong and it's gone, right? So I think you need to engage a savvy lawyer early to determine what you can and cannot do. Even if you read the trust and understand it and you go, I'm a smart person, I'm going to follow the terms of the trust. There's a lot of other stuff you have to do that you don't even know about, right? And you can make some serious missteps. So what I want to do is I want to take some questions here. Here's my book, Savvy Estate Planning, 2nd edition coming out, 02222022. It's a bunch of stories. It's not legalese. It's a practical guide to all the stuff that you really need to think about and decide before walking into the right attorney's office or Zoom meeting, as a lot of them are. So key takeaways here. If you're named successor trustee before you accept the position, please make sure you understand what you're getting into. You can check in, but you can't check out, so to speak. When you identify the successor trustee, you do have the right to decline the appointment. So when you're identified, if the trust has assets, you need to identify those assets and get custody of them and act reasonably. Once you identify the assets, you need to determine if you need to hire outside experts. Okay. CPA, lawyer, financial. You might need to hire someone like Randy if there's a conflict, and that's kind of his lane. And you need to identify the identity of each beneficiary. And this a little bit harder than it seems. If someone's died, you need to look at the trust. So if there's 3 kids and one kid died before mom, but that kid gets something, well, dead people can't inherit. That's got to go someplace else. Many times that requires frankly, a legal opinion. And you got to file the last income tax return. Remember, you do take on personal liability for the decedent's debts to the extent you have distributed assets, right? Beyond, right? It's sort of an early distribution. And then you have to pay creditors. And if you know a conflict's coming, communicate timely with the beneficiaries or their counsel. And I will say, if the beneficiary lawyers up and you're a trustee, you need to lawyer up. All right. I think that because that lawyer for the beneficiary is going to set you up as a trustee. Okay. I would just really be concerned about that. Do not ghost beneficiaries, right? They do pay attention. So don't just blow them off. Don't communicate, lack of communication. So subscribe to our YouTube channel if you're watching this on YouTube. If you're enjoying our stuff, review us on Google. Here is Randy's, and we have a lot of questions here I want to get to. Here is Randy's website, and here's how you contact him. If there's anything litigation, if there's, unrest, contact Randy. If you're setting things up or need some help and there's no drama, then you can contact us. So we have some questions here, and I would like to go through these. Terry says, I'm the trustee of the family trust, and now both my parents have passed. I have all the powers of the 112.0.2 Code of Probate as stated in the trust. Do I need to do anything besides pay all the debts and notify my siblings? I think that's out of California. Terry, you need to seek out an attorney probably licensed in the state where the trust was written under. And Sarah says, can a beneficiary become a trustee or co-trustee? Yes. If there was a fiduciary named in the trust, beneficiaries do not know who this person is, but he hired a fiduciary, but at the time of his death cannot find him. And when he is found, he says he is retired and sends a letter freeing himself of fiduciary duties. Can he actually do that? Yes. 13th Amendment to the Constitution prohibits you forcing him to do it, or prohibits a court from forcing him to do it. Sarah, contact our office. We can certainly help you with that.
Yeah, and let me just add one other thing. Most trusts will have provisions for if somebody refuses to accept it or they step down, there'll be what we call a successor trustee. So normally they will list at least 1 or 2 persons or entities that would take over if the trustee says, I don't want to act as the trustee.
Man asks, my successor trustee is named in the deep durable power of attorney, but not in the body of the trust itself. Is that the right thing to do, or the successor trustee needs to be named in the body of the trust? Man, I would say you need to have your estate plan reviewed. Typically, not always, typically the trustee, the successor trustee is the agent under the durable power of attorney. Not always, but that's something I would have reviewed. Craig asks, what is the best approach or team for my trustee, my sister, to protect her and not burden her with so much to understand? Can she hire a fiduciary or trust administrator and assume I'll have a trust protector in the process? And of course, CunninghamLegal, who is doing my trust restatement now. Craig, I would say that if you have somebody who's a novice trustee, hire a qualified attorney, a savvy attorney, whether it's us, whether it's Randy's firm, but I would hire a law firm, because many of our clients are individuals. They don't know what to do. They're along for the ride, but we guide them through that process. And so does Randy's firm. Arthur asks, besides your great videos, do you have any good book or other resources that discuss trust administration and what we need to know? I'm not sure the Great Trust Administration book has been written, Randy. It is a moving target. All right. This stuff changes all the time. When the fiduciary retired, so again, this is back to Sarah's question about the fiduciary. When the fiduciary retired and made me and my cousin co-trustees after doing my homework, I have documents proving that he has been stealing from the trust. Oh my gosh. As well as from my grandmother who had dementia. She put him on one bank account. Okay, so I'll stop here. Sarah, you need to reach out to Randy. If somebody is stolen, then that's something that Randy can help you with. How do you get a trustee to account? Can you file a document in court? Yes. Again, I'm the dermatologist. Randy is a doctor who treats sepsis, figuratively speaking. That's a sepsis case, right? That's something gone off the rails.
Let me just jump in just real quick. If you do go to court, it's a very routine matter to ask the judge for an accounting.
Yeah.
You know, trusts are outside the court system until there's a problem. Then the judge can intervene. And it's a very routine request that is generally always granted. The courts will grant. Now, there's different types of accountings. I won't get into all the details now, but if you want an accounting, the judge will accommodate you when you make the request, and normally they'll order it.
Arthur asks, what is the average amount professional trustees get paid? Banks get paid according to their fee schedule. Typically, private professional fiduciaries typically charge by the hour. Some counties permit 1% a year. Can one include a clause in the trust that would indicate should any beneficiary protest the trust, they lose their inheritance and get $1? Anita, unfortunately, yes, but there are many things a beneficiary can do that would not cause that to be activated, where they would forfeit their inheritance. So Sarah asks, are you going to answer my questions? I think we did. Can a fiduciary just retire and throw in the towel? No, they have to account. Okay. Can a beneficiary become a trustee when this happens? Yes. What can I file to get the accounting done? Talk to Randy. It's a court action. Typically, does the trustee get paid from the trust fund? Yes. Anita asks, would it be prudent to have a group meeting with the trustee and beneficiaries and discuss the terms of the living trust if it's a small group? I don't think that's a bad idea, unless you think it's a bad idea, right? Unless you think it's going to start conflict. Okay. Thank you, Betsy. Maha asks, my husband and I are co-trustees of a family trust that names both of us as beneficiaries and a special needs trust as contingent beneficiary. If one of us dies, does the living spouse, now sole trustee, need to contact a lawyer about what to do? Yes. So I would say if you have a trust, you need to contact a lawyer. It may be one meeting. It might be a long engagement, but you won't know, you just don't know what you don't know. How do I know whether my mother had a will or trust? Interesting question. That's a long answer. Someone typically tells you because they're under an affirmative obligation to tell you, but they could be ghosting you. And what I mean by ghosting you is not telling you. That's an interesting question. Sarah says, thank you. Any comment, any thoughts on that? How do you know if your mom had a will or a trust?
You want me to address that? Let me say this. This happens way more than you would think. People, sometimes the person who has the will and has the trust and basically got 100% of the estate because they committed elder abuse or acted with undue influence, whatever they did. Sometimes they won't send out a notice. Under the law, if you're the trustee, you're supposed to send out a notice to all the beneficiaries where they identified in the trust, and you send it out and you tell them, hey, do you want to see a copy? Here it is. You can get it. It also tells them you have 4 months to make a challenge if they're going to challenge what we're doing, as long as they provide them with the trust. So the point is, what people will do when they know they've done bad things is they don't send notice to anybody. Mm-hmm. So nobody knows anything. And then usually what happens is somebody in the family will find out that the person's died. Mom died, dad died, or whoever the person who created the will and trust, they've died. And once they find out they died, they start asking questions. Well, did they have a will? Did they have a trust? Who was their lawyer? Who was their accountant? I remember there was some lawyer that she used to work with. We should call that lawyer. And then what happens is they call the lawyer, and the lawyer goes, oh yeah, I did a will and I did a trust. Do you have a copy? Well, let me think about it. And then before you know it, the cat's out of the bag. And then the person who didn't deliver it tells everybody, oh, I forgot. I didn't know I needed to do this. And then what they've been doing is trying to hide it from the family. And then in the meantime, I have a case right now in Ventura County where someone got appointed as the trustee. They never sent notice to anybody. They transferred this home that they had in California, most homes, right? Almost $1 million. Sold it, took $900,000 in cash. And we got hired. We sent the lady a letter, say, hey, give us an accounting. Never gave us an accounting, promised to give it to us. We ended up having to sue her. So what she did was, when she buried the will and buried the trust, she took $900,000 and no one knows where that money is now. And so it does happen. Unfortunately, it happens more than it should. But normally, if you're trying to figure out there's a will and a trust, start with, Do we have a death certificate, confirm that they actually passed away? And normally think about who are the lawyers, who's the CPA, who were people around them. Sometimes friends will say, oh yeah, I remember mom had this relationship with this lawyer. Here's the lawyer's name. And that's how you could generally get there.
Josie asks, how do I know what stocks bank accounts my deceased dad had? Well, you should be told if there's an accounting. I think you can hire a private investigator to do a skip trace.
Well, also, if there's a trust, whoever the trustee is, they need to provide that information to you. Now, they'll sometimes be resistant. I won't get into details again. It's a long answer, like Jim said. But generally, if you have a legitimate trustee, they should voluntarily give you that information if you ask for it.
Anita asks, legally, does the trustee need to be notified they are trustee? No, in your living trust, they do not need to be notified. Should they be? Yeah, I mean, you need to make sure that they want to do it. But Randy, that concludes our time here today. Thank you so much.
Thank you. Thanks for having me. I appreciate it a lot.
And remember, subscribe to our YouTube page, and we will see you soon.